Today, Otiende Amollo gave his view on Spice FM on what happened between the two coalitions when they had their bipartisan dialogue committee negotiations, okay? Otiende Amollo gave this interview earlier today, and I only highlighted the most important part of the interview. I left some of it. You can go check the rest of it on Spice FM on YouTube. But here's the most important places, the parts that actually interested me. I want you to watch this, and I also compare that with the same interview in Spice FM where Murugara also was interviewed. Take a look and tell me what you think, all right? Here we go.
I'll come back to that. Let's just say that from that point henceforth, and I can show you like 6 or 7 steps, we realized that although they had called for bipartisan talks, they did not call them in good faith, they were not acting in good faith, and they were not committed. Let's just say we moved in bits and stops until finally we gave a notice, a 7 days notice, and said, if you are not going to move, then let's not give false hope to Kenyans. Decide. If within these 7 days you want us to move, let us move. If not, we will withdraw.
Saying when Azimio came, Azimio were actually the aggrieved party. The first step we as Kenya Kwanza took was to listen to them. Because you saw they're the ones who gave their issues first.
Yeah.
Then we also had to give our issues. And eventually they were saying some of the issues you guys are giving are an afterthought. We said that's an afterthought. Maybe we didn't even have the issues in the first place until you had the problems which took you to the streets. So when we went there, we had no guns ourselves. We had no bullets. We just carried green twigs of peace. To listen to these people, we hear what it is they have to tell us. But when we went to the table, it's when we discovered that possibly their expectations were more than what we thought. Because when they started telling us to bend the law, then we were worried exactly what we were heading to. Because we weren't prepared to bend the law. We were prepared to work within the parameters of the law, and where we felt the law was being unfair, we would actually have proposals for amendments.
When we agreed that, okay, there are some urgent interim measures that must be dealt with, okay? And there were 4. But 2 of them, one was dealing with the cost of living, the other one was desisting from interfering with political parties. Now, but we said there are 2 that do not need further discussion. One, let us stop the process of recruitment of IBC commissioners, because it's a substantive discussion we have to have. Secondly, let us write to IBC to preserve the status of the server, whatever status they are in, at least, so that when we talk about accessing the servers, there is no question that they were interfered with in the meantime. Now, at that point, they agreed, and we announced, and we agreed we were going to do the letters. We did the letters. I signed my part. When it came to my co-chair signing his part, he then said, no, it's as if they got some contrary instructions. He said, he suddenly took the position that we as a bipartisan committee do not have the power to instruct an independent commission, which is IBC, or an independent panel, which is the selection panel, on what to do. Therefore, he cannot sign those letters. So at that point, it became a question of principle, and we asked, if we cannot stop the process of recruitment of commissioners, then why are we discussing how to recruit commissioners? Because then by the time we are done, you'll have recruited them. And once you've recruited commissioners, you cannot remove them for 6 years. If we cannot have the power to tell IBC to preserve the servers, where will we derive the powers to tell them to open the servers, so to speak? So we said, then we are talking in vain. That is the point at which we said, okay, unless you change your minds, then let's just dissolve. We either use this or we break, you know. You remember before that we couldn't start because they had included Adan Kenan, who was himself the subject of discussion, because he was a member of Azimio, and we were talking about party discipline, and they bring him as if to sabotage, you know. Once we were done with that, we even agreed on the framework agreement. Then we said, let us identify the interim issues. We had our 4 interim issues. They needed another 1 week. And what they came up with were not interim issues. They said now they identified 5.
There was absolutely nothing wrong with Honorable Kenan.
As
It's
a
purely
person?
because, as a person, as a member of parliament representing Elders, nothing wrong. But purely because we don't like Kenan. We don't like him who he associates with. We don't like the way he has come in. Who are you to bring him here? Remove him. All right? We had issues with Kosing. We said, fine. Maybe
Because of who he represents? Or who he associates with?
even him regarding his party.
Okay.
We're still not satisfied. But he said no.
So you are draw there.
Yeah, we had a draw there.
Everybody had issues.
One person had to give in. Who gave in? Kenya Kwanza gave in.
So Kosing remained.
So Kosing remained, and we had to bring in somebody else. All right? We bent. The second demand that came in was we were not going to be parliamentary at all. We said, sorry, we will lack impetus in law. We will lack anchoring in law. We must actually have some law backing us so that when the time comes, we have somewhere to take the even if the principals refuse the documents, we have parliament to table that document too. We hangled over it, and we had to go 50-50, meet in the middle. We say, fine, we will have an element of extra parliamentary and parliamentary.
Okay.
So again, here we've bent to agree to it. Because when this was being set up, the communique that we got was it has to be within the parameters of the law.
Yeah.
Anything extra parliamentary was not within the law. So we bent here. We moved on. And you can see it is handle after handle. Now, we got to discuss the issues of IBC. Listen to what we're being told. You have to agree that the selection panel suspends its work. We said, under what law can we agree to this? No. We are above the law. Here we are not bound by any law. Here we are bound by our own whims. We said we can't agree to that. Absolutely we can't. What we do is let us request the selection panel on its own volition to agree to our request. Formally ask them. And most likely they are human beings. They'll understand what you are doing. That was disagreed.
Most
They said,
likely.
no,
Most likely
it is not going to.
So you establish that they are human beings.
Yeah, they're human beings.
as opposed
to-
Because, you cannot order selection panel under the law.
That's
you have
true.
to cite the law.
Yeah.
So what we did was
Request them.
we requested, that was my letter.
Yeah.
He redrafted it. He made it a resolution of the committee. I refused to sign. I said, this is not a resolution of the committee. It is a request by the committee. Now the next demand was we have to compel IBC to preserve the servers.
Yeah.
The question we asked, we are compelling as who? Where are we getting the power to compel an independent commission to do ABCD? What we do is let's cite the law. Let's cite the Elections Act and the regulations they are under. Remind them that they are under an obligation under the Act and the regulations to preserve election material for 3 years. I drafted the letter that way. Otiende Amollo rejected it.
On what
said,
basis?
He said, this is not good enough.
It has to be a resolution.
It has to be a resolution of the committee. So he said, sorry.
And the resolution, as you say, would actually be going against the law.
It could be going against the Elections Act.
Because you cannot order
You
the
cannot order
IBC.
IBC to do anything. But you can remind IBC it is bound
of their
by the law.
obligations.
Their obligations under the law. So that is the draft I had given to Honorable Otiende Amollo. It's a draft he rejected, and he gave me 2 different drafts. And unfortunately, I couldn't agree to this because to me, I felt they were going out.
I'm afraid there has not been good faith. Any talk such as this, you cannot start constraining yourself to the strictures of some legislation that this law says this. Because that law is the problem in the first place. We are talking about IBC reconstitution because the law that was amended was bulldozed, and it's a problem. You cannot say, the IBC is independent and therefore we cannot interfere when first the Constitution allows anybody to access anything that IBC has. But any talk such as this is actually premised on Article 1 of the Constitution. Okay. Any commission, any judiciary, parliament exercise delegated authority. So talks that are premised on behalf of the people directly enjoys sovereignty above what any other entity enjoys. Now, that is the one thing that our colleagues from the other side never understood, have never understood, and unless they understand it, the talks will go nowhere.
Mheshimiwa, let me ask you.
Kenya Kwanza, we actually had goodwill. And I kept on repeating that we were mandated to act within the law. And that's why they were saying, sorry, you're becoming a hardliner because you're insisting on the law being followed. And I was constantly telling them, sorry, you cannot do this because if you try to suspend the law at any one moment, that is called a coup. You are executing a coup against some legally elected government or instituted government or whatever it is. So we had goodwill. And this is why, in our view, the most urgent issue that had to be dealt with was IBC. The other issues were also pertinent. Reduction on cost of living, but we kept on asking, how is this to be done? The processes have to be administrative. They are not legal. And therefore, while we appreciate what you're saying, we have to be told how quickly it can be done, knowing for sure that as a government policy, we are moving away from subsidies. So that was on the table.
When this bipartisan committee was instituted, what was the understanding in terms of powers that were proffered to the committee?
Now, the understanding was simple. Because it is talks, or it was talks premised on the sovereignty of the people, it had all the broad powers that are necessary to make any recommendation, either to the Constitution or even to legislation. And therefore, you could not and you cannot constrain it by any of that. That is why in our appointment, nobody asked, but why 7 people? And where do you derive the power? Because it derives from Article 1 of the Constitution. Now, when then at that point you do not question the power to constitute the team, but when we seek to exercise what we are to do, you constrain us, then it means you are not acting in good faith.
Is that what is hoped for? A change of mind to say, come back to the table and let's talk?
That is what we hope for. Otherwise, then what was their problem with the IBC? The rest of the issues they are raising, including the finance bill, was not part of our talks. It was introduced the last minute. That part of our talks now in some parliamentary group meeting that was attended towards when they suspended, it's when the finance bill came in. And we told them, sorry, we cannot have new things coming up day and night because this is going to hinder our progress. So we said, no, it's going to be part of it. And we said, fine, if it's part of it, it's part of it. But as far as we are concerned as Kenya Kwanza, the common issue we had was IBC. And we are prepared to sit down, negotiate on the issues surrounding the selection panel. But if they don't come back, so be it. Let's go to the law. Let's have a selection panel in place. Let's constitute IBC. The rest of the issues, we shall deal with them. I heard them saying lawyers will meet lawyers, whether in court or elsewhere. We have no problem with that. We have enough lawyers, just as they also have enough lawyers.
Before I conclude this video, I just wanted to mention the last part of the last clip of Otiende Amollo when he talks about, he's saying that the talks were premised on the sovereignty of the people. I beg to differ, Mr. Otiende Amollo. This was a dispute between 2-party coalitions, okay? That was what the talks were premised on. So at no point did you have the sovereign authority to order or to tell or to advise the Independent Commission, IEBC, to open the server or do whatever, okay? So, and again, number 2, the other thing that I did not agree with Otiende Amollo in this was when he says he was constrained on what to do. Well, here's the thing. He was not constrained on what he could do, okay? The thing is, the other side's argument was, if there was any recommendation, okay, or any resolution that could be reached by these 2 parties, the other people, the Kenya Kwanza side, was saying that any recommendation or any resolution that is to be agreed upon should be brought up through the parliament, okay? The legislative body, which has the mandate, the power, the sovereign authority that's been given to them, donated to them by the people, okay? So that it can be made to law, okay? So this commission, this bipartisan dialogue commission cannot make something, come up with a resolution and claim that they have the authority, the sovereign authority to make a law, as Mr. Otiende Amollo wants us to believe. That's where I say Mr. Otiende Amollo was being actually sneaky about that. But anyway, thank you for watching this video. If you haven't subscribed to my channel, go ahead and subscribe. I'll give a part 2. There's a part that I haven't actually posted because I didn't want to make this video so long. But there's a part 2 that I want to mention, something that Otiende Amollo said that really, I think somebody should have corrected him. But anyway, again, if you haven't subscribed to my channel, go ahead and subscribe, share, like, and comment. I'll talk to you guys later. Peace.